Good morning or good afternoon or good whatever it is, wherever you are. I'm Colm Brannigan. I'm originally from Dublin, but I've lived in Canada for eons and eons. And I'm based in the Toronto area. And I have a fairly mixed kind of ADR practice. I've been mediating and arbitrating for 20 years. Prior to that, I practiced law. I started as a family mediator and then moved on into different areas where I do a number of quite interesting areas, actually. I do commercial, some construction. I do a fair amount in housing and real estate. And I have, over the last few years, been working on developing the use of MedArb as a process. And so what we're going to chat about today is just that. What is MedArb? Because my research has shown me that there's different understandings of it in different places. And so one of the things I'd like to do is to chat about what I see as MedArb, and I'm really looking forward to having a discussion about it because it's quite a controversial process and has kind of come to the fore and then receded and done that again. And, you know, a lot of people have looked at it since the early 90s anyway. And it's used in different parts of the world and it's used in different models. And I've actually developed a different kind of model. I'd love to say it's mine, but it's based on synthesizing parts from different places and different laws. So MedArb has traditionally been looked on as being a hybrid, a mishmash of bits of mediation and bits of arbitration. It's used, for example, in Ontario in family law disputes, and it's used in labor, and I mean union labor disputes. So those are the two areas it's used a lot in there. Last couple of years, we've been using it more in commercial and condominium strata type disputes and just estates, things like that. So it is being looked at, and I'm just kind of situating this for my overall talk. A couple of years ago, the ADR Institute of Canada decided it was time to look at MedArb again and set up a task force. And we met over a period of about a year or 18 months and came up with a set of integrated MedArb rules. We also decided to look at the process as an integrated process, not just a, every now and then ad hoc process. So based on that, as say, rules came out, and these rules, as far as I'm aware, are the first rules that have actually been put out by an ADR group. And they're quite straightforward. They do speak to the differences in MedArb, but they also refer to both mediation and arbitration rules of the same organization. So we decided we'd take a look at it, and we took a pretty in-depth look at it and its use in different places in the world, mostly within common law jurisdictions, but in other jurisdictions as well. And a couple of things have come out of that, and the title of today's discussion is MedArb Empowering Uncertainty. And in many ways, that encapsulates what's going on in MedArb. So what I'd planned to do is I have a slide deck. We always have to have PowerPoints to fall back on when we can't go anywhere else. But I don't use PowerPoints as the be all and end all of it. So there's some key points on the PowerPoint that I'll refer to. But I really just want to go through the process as I see it, and then hopefully we'll be able to pull together different ideas and look at it. So it's pretty informal from my perspective. I'm delighted to be here because it's great to have an opportunity to discuss process with colleagues. We're often too busy doing stuff, and we also get caught up in doing processes the way we always do them. And what I'm suggesting with MedArb is that it's a process that maybe we need to look at a wee bit more. So I'm going to, I guess I have screen sharing here, don't I? Okay, so I am going to screen share and bring up my slides and then make everybody watch them. Okay, so can you see the slides okay? Good. Okay, so as I say, my background, my interest is MedArb, but it's also in online dispute resolution. And the two of them have come together nicely in the last wee while. So as I said, we'll look at MedArb as an integrated, standalone process. To me, that's the key. Okay, we're going to move away from the idea of med-arb as, oh, let's pull bits of mediation and arbitration together, and we're going to start looking at it as being an integrated process. And that's really important from a legitimacy perspective, because when you start talking about med-arb, you immediately get pushback, and we can go through part of that as well. So I'm going to quote, to try and bring people in from all over the world, I'm going to quote Alan Limbury in Australia. Med arbitration has the advantages of offering both the possibility of resolution by the parties on agreement, and failing such agreement, the certainty of resolution by the binding decision of the arbitrator. Okay, I think we all know that if we've looked at med-arb at all. And that's that. In a course that I once was in on med-arb, one of the participants said, med-arb, that's really mediation with teeth, which some people were horrified by, and other people thought, well, yeah, maybe. So there's two aspects to it. The ADR Institute of Canada has med-arb rules, and it defines med-arb. And again, same thing as Alan Limbury said, attempt to settle a dispute through mediation, and we call that the mediation phase, use binding arbitration to resolve any issues remaining after mediation, the arbitration phase. Right at the beginning, I'd like to just make clear that because of the way the processes come together, med-arb is actually a submission to arbitration. That's technically your med-arb agreement, or how you do it, is a submission to arbitration. And it's therefore subject to your arbitration rules and statutes. Otherwise, the process can be plugged in anywhere. It's just you need to be aware of what your act says, right? So the options that we've had traditionally, the first two options, and the ones that people are used to, single neutral does both. You do the mediation, then if it's not successful in resolving all the issues, the same person switches hats and becomes an arbitrator. The other model that's fairly common are two neutrals. So you have a mediator and an arbitrator, both designated in the beginning of the process, and you move through the process that way. The single neutral model has many, many benefits, at least of which is that you don't have to educate the mediator as to what's going on in it as arbitrator, and also cost and time. The drawback to that, and one of the criticisms of it is, oh my goodness, how can you switch from being mediator to arbitrator, and how do you forget what you know? So because in the US that would be called a due process issue. In most other common law jurisdictions, it is a natural justice issue, bias and natural justice. But those are the two models. But there is a way around that. And the model I use is the idea of a single and neutral with an opt-out. Now, I'd love to say this is my idea, but it's not. It's been around for quite a while in Asia, and my actual model comes out of Australian legislation. And so I have taken those and synthesized them into this different model. I've also designed it in a slightly different way from phases, and we'll talk about that in a sec. So having a single neutral and opt-out, what does that mean? Well, that means you hire your mediator / arbitrator at the beginning, and the idea is they will take it all the way through. However, at the end of the mediation, the parties or the med arbitrator can opt out and say, no, we're not comfortable going ahead with you as the arbitrator. Or as the mediator, you may say, I'm not comfortable going forward with the process. And it may be, and we'll come back to this, that perhaps in part of the mediation you said something or went a wee bit far that may make people think that you've already made up your mind. And of course, that's pretty crucial. The good thing about the opt-out provision is it takes away this idea of there's some kind of denial of natural justice by the same person performing both roles. It also supports self-determination because you're providing this option. And in mediation in particular, and also I think in all alternative dispute resolution processes, self-determination and informed consent are the key. So we have this single neutral, and that's the one I've been using for about 2 years. And although I don't keep stats, because I think we can all discuss for a long. Sorry?
Did you say you were welcoming questions in the middle, or do you want
Absolutely,
questions in the chat?
I'm happy to have a question at any
Yeah, I
time.
certainly don't want to disturb your momentum. I was wondering about this opt-out. What happens if somebody opts? Are you saying any one of the three? So you've got the neutral plus the two litigants. You've got three people, and if any one of the three is uncomfortable with it, then he opts out.
Exactly.
Right. So when he opts out, then what happens? A second person steps in.
Well, that's it.
Are you coming to that?
Yeah, I mean, that's exactly what happens. I'm about to discuss it now. So if you opt out, there's two different kind of approaches. One of them, the first thing and the most important part of this is the parties are still locked into the Med-Arb process. So you can't have the situation where they say, oh yeah, okay, we'll arbitrate it, but then they'll take lots of time to find the arbitrator, and it defeats the object of having the process set out. Yeah, so I mean, that's a problem. I mean, in our Arbitration Act, I mean, you can go to court to appoint the arbitrator, but that's ridiculous. You're trying to stay out of court. So what I've found is either the arbitrator, that's for want of a better term, the standby arbitrator, is either picked at the beginning by the parties and basically is set out in the agreement. And I'll talk about the importance of the Med-Arb agreement because it's kind of fundamental. Or, and this has happened in a number of my files, the parties hire me with the idea I'm going to go through, but then for whatever reason we don't. We've set out a process where they provide me with names, and they essentially empower me to pick one of the names off the list. And therefore, the process is still locked in and goes forward. So there's different ways of approaching it, but essentially the key part is everyone is still locked into the process. And so you're still moving ahead, because if you have separate mediation and arbitration processes, as indeed we do under some of our legislation, you often find that in the gap between the mediation ending and the arbitration starting, there's lots of squabbles over things like who the arbitrator will be, sometimes having to appoint them by court. So this tends to integrate it all. And that's part of why I'm looking at it from that perspective.
What about the cost? Does the cost go up because you're appointing a new arbitrator? And if so, who pays?
The cost will go up, and that's a risk you take when you go into the process.
Taking the risk that either one of them can decide he wants to go along with a new arbitrator, and yet the other one will have to foot half the cost because that's what he signed in before to start with.
Absolutely. And the advantage of that is having certainty that you're moving through the process, and also preventing challenge to the arbitration award.
Absolutely, yes, fascinating. Thank you.
You know, it really does provide that. In fact, my agreement in it has a provision that you will not challenge the process, that you've agreed to the process and you will not challenge it. I mean, it's one thing to have your award appealed. That's okay. If you make a mistake and court corrects that, that's fine. But you don't want the process attacked. And so designing the process, I've thought quite a bit about that. And we can go into it in a wee bit more detail, but that's a good question because it is an issue. The big advantage of doing it this way is it's efficient and it's fair, and the parties often feel that they've done the best they can in mediation and are prepared to accept that they have to go to arbitration, and they're prepared to accept, if they are happy with the same neutral, that you deal with it. I don't keep stats on resolution or settlement because I think, much like many other things, it's how do you define that? But I have been keeping track on my Med-Arb cases for a couple of years now. And we'll take 20 cases, although I've done a lot more. 20 with opt-out. 15 of the 20 resolve completely. So that's pretty much what you'd expect in mediation anyway. So then we've 5. Of those 5, 3 go on to arbitration. In that group, only one of them is likely going ahead with the full range of issues. So you have a much narrower range of issue in the other 2. It's sometimes a single issue. So what's happened is essentially you funnel down the issues through mediation towards adjudication, and the adjudication is much simpler. And the opt-outs I've had have been, well, it's only been a couple, and it's been split equally between my opting out and the party opting out. My opt-out is normally because I got too carried away in the mediation and could see we were so close and maybe pushed a little harder than I should have. And although in both cases that I'm thinking of, the parties were okay with me going ahead, I thought I'd overstep the boundaries, and I'll come into those when I'm talking about mediation. In the other one, it was counsel for one of the parties was upset because I asked a question in caucus that they didn't like me asking, and it was to do with strengths and weaknesses of case. So it was a bit more evaluative than maybe I should have been. However, what's key to me is that 3/4 of them are resolving, and I'm finding the resolutions to be better than if it was just mediation itself, because the parties are coming to this far more prepared, knowing that the arbitration will take place, if not necessarily immediately afterwards, then shortly afterwards. So you get a level of preparation that unfortunately is not as consistent in mediation only. So I found that that was an unexpected bonus. But any of those questions we can certainly come back to, or feel free to ask. I'm quite happy to move from this, and I'm also quite happy to do it because a lot of these questions may be ones that I haven't looked at before, and I really want to have the opportunity to have a discussion because it is kind of different, and that's what we want. So
Sorry,
move on a bit.
I don't really want to ask a different question, but I think I may not have understood something properly.
Okay.
So out of 20 cases you're thinking of, 15 settled at the mediation phase.
Mm-hmm.
Right, so it didn't involve any arbitration at all. And some of the others, you only had to arbitrate a limited number of the things.
And that's a huge benefit, rather than going into full-blown arbitration. And it's not that I'm against that. I mean, I belong to the CIRB, and I've got some designations in arbitration, but I find that the MedArb process is actually far better for many cases, because there are advantages in it that you don't have in the separate processes. So I'll go through the model, but we'll come back to this because I think this is really important. Okay, where's my, there we go. So I've designed this as a 5-phase process. Now, traditionally, it's been looked on as a 3-phase process when it's been looked on as any kind of process that's standalone. So we've always thought of it as the mediation phase, the transition between mediation and arbitration, and the arbitration phase. Okay, but that doesn't really explain it. So I've decided that it's better to look at it as a 5-phase. The 5-phase is, first of all, designing the process. Now, that's the part that ADR professionals love, is doing design work. So it's probably not going to get the same warm and fuzzy response from counsel, from lawyers, because they just want to get into the process, get the job done. So the way I've looked at this is designing the process really is the MedArb agreement. Okay, and that's the important governing document, essentially. So we go from there. So we look at what's in the MedArb agreement, keeping in mind that, as I said, this is a submission to arbitration. I'll come back to the agreement and what must be in it. But to me, it must have a written agreement. Okay. Yeah, I just had a comment from Windsor about, yes, they do arrive much more prepared. Right? In some of our jurisdictions, we have a mandatory mediation program within court-connected disputes. And many times it's not working very well because it becomes a tick the box and get through it on your way down into the real litigation. I find that in MedArb, the mediation phase is taken much more seriously. It's because people are preparing to move, if necessary, into arbitration. So it's got a wee bit more front-end loading in terms of time. And it's not for everyone, because you really do need counsel who, although they may be very adversarial on the issues and advocate for their clients, they're prepared to be collaborative on the design. And that's happening with the group I deal with quite a bit now. So we'll come back to the agreement, but it's the key. We have to have the agreement. Without the agreement, we have potential problems with the arbitration phase. So then we go into what's really the next part. Let's see. That's what everybody thinks of as a MedArb. Mediation phase, transition phase, and arbitration phase. Now, these slides are available afterwards if you want to look at them, but they're not very complex. This is the part that all the trouble happens in, the transition phase, right? And in Canada and in the US, there's lots of great case law about how not to do in MedArb, and not a lot about how you do it. So by looking at some of the cases, you can see that one of the problems with the transition phase is people don't know they're in it and don't necessarily realize they've moved out of mediation into arbitration. So it's crucial that the transition phase be handled properly. Otherwise, you may have challenges around process, and rightly so. People can only give informed consent if they actually know what they're consenting to. So part of managing the MedArb process is really managing the transition phase. And what's involved in that can vary depending on the nature of the dispute, but that's very important. And that's where most of the case law talks about. You know how in standard arbitration, we talk about pathological arbitration clauses, and they take up a lot of the court's time. I think in MedArb, we talk about pathological transitions. They're not done right, and then, you know, things happen and your word gets challenged. So those are the phases, and that's traditionally what people thought of, but I've added on to that. I've also added on the other end, the decision-making phase, writing the award. And what do we write in the award, and you know, how much detail in it and things like that can be decided as you're putting the agreement together. Okay. So I've mentioned some case law. It would be easier if you'd like some case law. I have some case law, and you can email me and I'll send it to you, because I have a collection of both Canadian family cases and some other cases. And I refer to one of them in here, but I decided not to go too deep into case law because I wasn't sure the audience and the interest, because you don't need me droning on here in Toronto about cases. But I'm happy to share it. I've also put together a list of readings on MedArb that, again, I'm happy to share with you. I put those together for a course that I put together on MedArb. There's not a lot of courses around, so this is kind of a backup when people want to know more. And my email address is at the end of the slideshow, but it's a pretty easy one, and I'll come back to it. So happy to do that. Most cases just say what a mess it is and don't really help, but you can avoid much of that by thinking it out. So writing the award, but you need to think about who's you writing the award for. For a long, long time, I think we emphasized writing the award for a reviewing court. That's not what we should be doing. We should be writing the award for the parties. And people who understand the award are much more likely to accept it. And in fact, people accept the arbitration outcome in MedArb far easier than they do the arbitration award in a full-blown arbitration, because they know that they have made a big effort to resolve it. They couldn't resolve it through mediation. They know it has to be adjudicated. So these are the little things I didn't expect. We'll also talk about when MedArb is appropriate. And what MedArb does primarily is provide the opportunity to maintain a relationship through the mediation phase of it. And that can be important in family, as we see in Ontario a lot. It can also be really important in commercial, where companies have to do business with each other, but they have ongoing disputes. So they mediate it, limited arbitration, much more likely they can do business together. So to me, there's a huge potential for using MedArb in small business to medium business disputes. And I think we need to look at that as something to do. Okay, the core principles from my perspective, and none of this obviously is anything other than my ideas on it after looking at it for a wee while. If we truly believe in ADR, actually, the question is MedArb used in major civil jurisdictions: Mexico, Germany, France, Netherlands. It is used in limited ways in most jurisdictions. It's not just restricted to common law. We see it used, as I say, a lot in Asia, as well as the reverse of it, ArbMed, which I'm not going to go into because that's another story. But it is used, and there's some literature on the international use of it, which again, I can probably point out to you. Yeah, I've heard you're writing for more than the loser's loser. I think you're writing for both parties. You're writing for understanding. I would say you're writing for the winner as well, in that you're writing an enforceable award to prevent another dispute arising out of the award or interpretation of the award. But I think we are looking at different audiences. And one of the things you would do at the beginning of the MEDARB process is discuss the depth of reasons you might want to have in the arbitration award and things like appeal rights, if there's going to be any. So if you believe in ADR as a process, or maybe even more than that, because a lot of people who work in ADR see it as being, just a true alternative or a more appropriate way of dealing with conflict and disputes, one of the things we have to recognize is that the parties are free to craft the process as long as they've informed consent. So what does that mean? In MEDARB, it means that despite the misgivings of lawyers, the parties are entitled to consider MEDARB as the dispute resolution process in their dispute. It's not going to work in any dispute, but it can work in many kinds of disputes. And I think lawyers need to bring it into their toolbox. And of course, because it's different, because we've kind of got an idea what mediation is, and we've kind of got an idea what arbitration is, oh yeah, you can do it in labor and union type stuff, but not in the stuff we do. I think we need to get over that. I think we need to listen to our clients. And one of the classic books in ADR to me is Bernie Meyer's Beyond Neutrality. And if you haven't read that and you can get your hands on it, it's worth a read. But one of the things he says is we don't listen to our clients. We are the experts, whether as ADR process experts, substantive legal experts or what, we look at the dispute, we fit it into the box, and we don't listen to what our clients want. Most of our clients want it over. Now, I'm not talking about high conflict individuals. I'm talking about people who are in a dispute and want it done. And so we should be looking at how do we provide extra options? And one of the options that, as I say, I've been using quite a bit, probably, way more than I've been doing just straight mediation and arbitration for 2 years now, has been MEDARB. To the extent that I'm now having lawyers come to me and they've already figured out the process, which is so dramatically different than 2 years ago, where I would have to essentially sell the process as an option to be considered. So people are, at least in my jurisdiction, beginning to look at it. The other core principle is that the Med arbitrator is bound by the rules of natural justice. It's not a free-for-all. It is actually an arbitration process, and that's why I said at the beginning it's a submission to arbitration. And we also have to look at natural justice bias and other issues in mediation anyway. But that's that. Okay. So what do I mean by natural justice? To me, and to most of the literature, natural justice means what? Notice of what's going on, notice of the dispute. And that could be, notice of mediation, arbitration. It could be a lawsuit, statement of claim, originating process. The right to a fair hearing, to know what you're up against and have a fair hearing, and an unbiased decision maker. That's where we sometimes run into issues with MedArb. Because people say, wow, you've been the mediator, how can you be an unbiased decision maker? And that's something you need to think about. I actually believe you can, and have been doing so successfully, and I know others who have. But it's something you may want to think about. Right, so MedArbs, what are the must-haves? Let's give you a written agreement. And I'm happy to share my agreement with you if you would like to see it. You will have to make sure that you understand your own legislation, your arbitration legislation, in case you do have to arbitrate it. Some jurisdictions are very open on the arbitrator being involved in settlement, some are not. Across Canada, you can do that, except in Ontario, which has a provision that is waivable, but it basically says, oh yeah, mediator, you can be the arbitrator, but you can't go back the other way. And yet sometimes it does. So, know what your arbitration rules are, your legislation. But other than that, it's pretty much a process rather than bringing law into it. So again, I'm happy to share the one that we've worked on for years, with you if you think that might be helpful and you're interested in looking further. And it goes without saying that I'm always happy to be engaged in a conversation about this. So if you wanted to carry it on again at a different time, I'm happy to do that because I'm still refining it. There are distinct phases in the process. And as I said, people look at 3, but there really are 5. It's at the beginning in the design where you work more with the parties' representatives or lawyers to talk about it, how information flows through the process, what's going to happen in mediation, what's going to happen in arbitration. And the key also, the transition. And if it's going to go wrong, it's going to go wrong there. So that's the part you need to pay attention to. Okay. The benefits of it. It's faster and less expensive. My own stats tell me one of 2 things. One, it's about 60% less expensive than doing separate mediation and arbitration, or 2, I'm not charging enough money. I'm not sure which it is, but let's assume, because I'm trying to push the process, that it's actually less expensive. So even if you could reduce the cost of 75% of the separate processes, and given the speed you can bring into it, as long as it's fair and the parties understand what's going on, it makes sense. And we should have it as an option. Usual ADR benefits, privacy, flexibility. A big one, as I say, is potential for preserving relationships, which we have in mediation. But once we get into arbitration, we generally lose that. What I'm seeing is a greater acceptance of outcome. And therefore that will preserve, I think, business relationships in particular. It can be customized. You can decide what kind of process you want, but it gives the definite outcome that is often a criticism of mediation. Now, I don't necessarily subscribe to that criticism because you don't know what the outcome really is in mediation often on the day, and you'll often find out that people have resolved their differences. They just needed to be brought together to start thinking about it. So I don't see that as an enormous problem. I think it's one of the parts of the process that sometimes takes a wee bit of time to work out. But I do see in MedArb the advantage of a definite outcome. Now, there's a criticism that's coercive. You bring me into mediation, you're going to arbitrate, it's coercive. Well, the whole system of dispute resolution has aspects of it that probably wouldn't stand up to a really significant investigation of how coercive they are. And all kinds of systems that are going to have adjudication have almost a built-in coercion, which is, I think, too strong a word for what's going on. However, as long as people know what they're doing, that's for their lawyers and themselves, and your process is straightforward, that's okay too. The challenges to it. For those of you who use caucus in mediation, the individual sessions, how is that impacted by the fact that you might end up as arbitrator? Are you going to use caucus? In North America, the caucus model is predominant in commercial disputes. Lawyers jump into it. In fact, many now don't want to have openings. They don't have joint sessions. Well, shuttle mediation may or may not appeal to you. In some cases, it makes sense, but becoming the dominant model, I think, takes away a lot of the potential for better outcomes. And so you want to think about that. Do I caucus? What do I do with information in caucus? We have 2 options in most mediation that I do. Everything in caucus remains in caucus unless you give me permission to take it away from it. But it might be that there's no confidentiality because of the MedArb process. Again, these would be discussed with counsel and clients beforehand. What do you do with confidential information? So we decided about the caucus, but you have information. What do you do when you go into the arbitration? What I do at the end of the mediation phase, I essentially sit down in caucus with one party, talk about the information, ask them what they're prepared to bring forward into the arbitration or reveal, do the same with the other group, and then bring everyone together. And generally speaking, you find that the information that they would rely on in arbitration, they will bring forward because it's their responsibility to do so. And I have a slide a wee bit later I'll show you, but I'll give you my view of it. Mediation is based on information. Arbitration is based on evidence. Information is not evidence. So a lot of the fear of you finding out something is immaterial because you have to make your award based on the evidence in front of you, not the information in front of you. And so part of it is designing documents. For example, we use mediation briefs where people counsel prepare a mediation brief, mediation statements, key documents, etc., exchange them with the parties and provide them to the mediator. In MedArb, we design those so they can be carried through, or at least portions of them can be carried through into arbitration, so they're not, starting from scratch and rebuilding everything. Again, that's the really interesting part from an ADR practitioner perspective, is helping the lawyers design that part of it. The impartiality and bias issues is a big one. I think I've dealt with that by providing an opt-out, right? If you, after going through the mediation and have the opportunity to opt out with no consequences other than perhaps some costs, which can always be dealt with later in arbitration, it makes it very difficult for you to attack the bias issue, perception of bias of the mediator arbitrator and their impartiality, because otherwise, if you felt that way, why wouldn't you have opted out? So I think it provides a safeguard, but I think it's also really important to provide that opt-out because that's not in the traditional model. And that's where people attack the arbitration award based on the mediator was showed during the mediation that they were on their side. They weren't impartial, they weren't listening, they were biased. We don't want that. Part of our job is to produce the enforceable award. Well, our job's really to help people come up with their own resolution. If that fails, produce the enforceable award. And as part of producing the enforceable award, don't start another dispute, which is what you do if there's a problem like that. So those are issues, and natural justice. Those are all the ones that are in most of the literature, all over the place. So we have to look at that. What do we do about that? Well, I think it's pretty straightforward. The med arbitrator has to explain the process and the dual role, and that gets done at the beginning. And then it gets done again at the transition, right? Make sure you've got the informed consent. I have an agreement. At the transition stage, as part of putting together the issues that are going forward, I'll have the parties agree to that in writing. So you're protecting the process as you go along. And that's the informed consent. And then in an impartial manner. Well, if you do arbitration, you have to do that anyway. And I trust that anyone who takes on this process has the ability to do that. Favoritism can become an issue if you're dealing with the same parties or lawyers. And I've actually arbitrated. I did an arbitration 18 months later, the parties came back to me, which surprised me, slightly different arbitration. I said, well, I ruled against one of you. So it's okay, we were okay with the process. People have to be okay with the process. If you know the lawyers or other parties you're dealing with, obviously you disclose those. The best, I think, guidelines on disclosure are the IBA guidelines, their traffic light system, which you can use. Most are waivable, but you need to bring them up. Yeah. And a good question, who decides to give up on the mediation? And no, the parties control the process and mediation, but you manage it. You control the process, and the main control in the mediation is deciding on giving up. I have found, if you spend a day in mediation, you're not going anywhere, you probably should move on, but I would discuss that with the parties. They have the right to decide to do so. I can say, and I often do, okay, we've got rid of 6 issues, we've got 5 here, maybe it's time to move on to arbitration. And generally people will say, oh no, we'd like to try a little harder. And generally we'll knock out 1 or more before we actually move on. But you're not going to waste your client's time, but neither are you going to jump to arbitration. Because if you can help them come through it with a mediated agreement, we all know that that's more likely to be implemented and more likely to be sustainable because they've put it together. But the mediator manages the process and manages it in MedArb as well. So, we do have the power to not waste time, but we want to let people run the process as much as they can. I rarely have to do that. People kind of get to the stage and they know, oh, you're not going to get settlements. What are we going to do? So the mediation phase, people may not want to share information with you if they think you're going to be the arbitrator. But in reality, I don't think people share information with you anyway. They share what they want to tell you in the mediation. You don't know the story. You don't know all of it. And will your effectiveness be compromised? And that's one of my opt-outs, was I went too far. So I think the opt-out preserves that. I'm just raising them as questions. confidential information. What do we do? So these are more questions than answers. Should it be considered during the arbitration? Well, it depends on what you've agreed to in the agreement and the process. And also, is it actual evidence? What if the parties are not aware of the evidence? The matter proceeds to arbitration. Well, they may not be aware of all of the evidence, but they'll be pretty much aware of it after the mediation and after the issues that still have to be dealt with are set out to go forward in a procedural order. As I said earlier, caucus or not caucus, this is to be your decision. But it is an interesting topic. If parties understand what's going on, they will be more open. But they may be reluctant to give you some information. You're just going to have to accept that. It's their choice. You're not there to pull the information out of them. You're there for them to help pull out the information that they want to provide to help them come to a resolution. And yes, you have to be very cautious about comments. Now we have a wide range of mediation styles, ranging from extremely facilitative all the way through to quite evaluative. Evaluative to me does not mean you win, you lose. It means looking at strengths, weaknesses, and risk analysis. But if you're going to use that model, you need to be careful what you say. Okay, this is the key point. Okay, information is not evidence. When you get to the arbitration phase, it's an arbitration. So what comes over, if any, either the parties agree that's evidence, or they have to put their evidence in the way they would in any arbitration. So there's often confusion over that, and that's your job, is to sort that out. This idea of the lack of confidence in your ability to forget, what they're entitled to know is you've kept an open mind. And you need to reinforce that as you're talking to the parties at transition and everything else. And then the lack of clarity. You must say, look, the mediation phase is over. We're now transitioning to the arbitration phase. It's crucial to say it clearly, because you'll find many cases where people thought they were in the other phase and were surprised to find out they weren't. That shouldn't happen. Okay. This is a case from Ontario, one that you have put in. It says if the Met arbitrator must move, it cannot be expected that he or she can entirely cleanse the mind of everything learned during the mediation phase and of every tentative conclusion considered or even reached during the mediation phase. In other words, this case from Ontario says, you're going to remember some things, but it's maybe not that important. And our courts have been very supportive of MedArb after initially not being supportive since I guess the 80s, they've been very supportive of it. But this is a relatively recent case. And I think this is the key to it. Judges hear things that's not evidence, and they manage to deal with it quite well. So arbitrators can do the same. And this is the key from the same case. You're open to persuasion and you won't have reached firm conclusions. Again, judges do this and you can do this. You won't get to do that if the parties don't trust you, and that will become pretty evident during the mediation or when they decide to opt out. If you go beyond that, then the parties trust that you will do this. And so really it's, how do you engender that trust and what do you do? So the purpose of the award, well, it's to determine the dispute. So you don't put stuff in the award you don't need to put in, and you are limited by your powers that have been given to you by the parties. A thing I always remember writing an award is the idea of Chekhov's gun. And Chekhov basically said, if there's a gun on the wall in the first page of the novel, then it better go off sometime during the novel. And if you apply that to arbitration, that means don't put stuff in that you don't explain in the award. So write it carefully and to inform the parties about the decision, right? So reasons. The reasons show that it's based on the evidence. And again, you may decide on the level of reasons. From the case law, it's clear that reasons don't have to go into every detail. So again, some cases may require massive arbitration decisions, others don't. This is not trying to duplicate international arbitration and complex awards with much better process and procedures in international generally than domestic, but the awards tend to be quite complex, where this is saying it can be adequate. Okay, you must look to as I said earlier, your legislation, because that's what it's based on, and one size doesn't fit all. And the key, and I've seen agreements which people haven't said, you know, this is what we're going to do. It's going to be, I'm going to be the mediator. Oh, really? Okay. How do you submit factual issues? A lot of the mediations I do, and then go into arbitrations, we do document-only arbitrations because we've narrowed the issues down and credibility isn't an issue, and it isn't in many cases. And then the waiving the confidentiality of mediation. Again, you talk about this at the front end. What are your ethical obligations? In those, you need to look at what your professional organizations say. But it seems to me, you know, we've got the same ethical obligations as a mediator or as an arbitrator, and they fit in together for the med arbitration. Is there conflict? I don't think there is, because you can reconcile it by explaining it to the parties. It's up to them. We're the experts, but it's their dispute. If they know what they're doing, we should encourage them in most cases to look at the alternative that works for them. And I mean, I think that's important. I think we often, you know, forget, although we say, yep, we're all about self-determination and consent and everything else, but because we're specialists in what we do, whether in substantive areas or just in process, we tend to default to what we're used to and assume that's what the clients want. And I don't think we should do that. Okay, so in my view, I think MedArb is the ideal process in the right case. I am not saying for all cases. It provides what we want, the parties with an opportunity to reach resolution on their own, which are held, but the certainty. And that's a huge thing. And to me, the other part is preserving relationships, which is important. And let's see what family, estate disputes, commercial law, almost anything you can think of. If we really believe, and the minimum empirical research we have supports mediation can foster rebuilding and repairing relationships, and you have to have an ongoing relationship, MedArb's something your client should be looking at. So it's not really magic, and it's not a cobbled together, oh gee, we're just going to pull something from here and there. It's an integrated standalone process, and it deserves to be used more than we do.